Hi, everyone. Welcome to SNAP and Immigrant Communities, Understanding Eligibility Changes and Protecting Access After H.R. 1, co-hosted by FRAC, the National Immigration Law Center, Protecting Immigrant Families, International Rescue Committee, and Refugee Council USA. I'm Steve Hayward, FRAC's Communications Manager. Before we begin, I'd like to cover a few brief housekeeping items. We expect this webinar to run about 60 minutes. We are recording the presentation and will send the recording and slides in a follow-up email. Closed captioning is available. To turn captions on, click Show CC in the bottom taskbar and select English as the spoken language. At the end of the presentation, we'll have time for questions and answers. To ask a question at any time, please use the Q&A tab, also in the bottom taskbar. With that, I'll pass it off to Gina Platanino, SNAP Director at FRAC. Take it away, Gina.
Hi, everyone. Thank you so much for taking the time to join us today about this very pivotal topic. We know that is one of many things that are constantly ongoing that are shaping the way that this program operates. So we really do thank you for being with us. As Steve said, you will get a follow-up email with the recording as well as the PDF slides. We ask that you please go ahead and put any questions that you may have, and we hope to have enough time to address them as we go. Our webinar today, we will give a brief overview about SNAP, how important it is, who utilizes it, what are the changes that are coming our way that are already here that impact immigrant families. We'll hear, we'll share who are these families, who are these individuals who make part of our community and how these changes will impact them. We'll hear about how HR 1 specifically made a provision within SNAP that will be impacting these particular communities. And then we'll end with a general overview about the changes that are coming for immigrants within the public benefits space. And we will have action items and action steps that you can take to help us protect these very vulnerable communities and ensure that we grant access to as many people as possible. Next slide, please. Next slide, please. Before we get started, I know it's been a while. It feels like July was like months away, but HR 1, which was signed in, which is the reconciliation law, and it has other names, was signed back in July 4th by President Trump. This was pushed by majority of Republicans who really wanted to curtail these programs. They wanted to ensure that these benefits went to certain individuals. And in order to pay for these benefits, these tax cuts, which raised our debt ceiling, they cut a lot of specific programs. You know, we deal with SNAP, so that's what we will talk about, but they also cut down Medicaid, the biggest cuts that we've ever seen. It cut down other provisions within education and so on. So it's important as we talk about this topic to understand what, if anything, gained and really who were the winners and the losers, because unfortunately, they are those two parties. But this 4 trillion in tax cuts, right? This policy decision was mostly for the wealthy. When we talk about wealthy, you know, you have to be making over $1 million. You're within like the 90%. You're making a lot of money. You know, it's large corporations, right? On top of this, they made them permanent, right? The previous tax cuts that came from the first Trump administration were provisionary, and they made it permanent. That means they're not going to set to expire. Over 1.5 trillion for millionaires and billionaires, right? And special tax rates for the biggest and largest business and corporations, right? There were some small provisions that were made for families, but incredibly minuscule, and those do expire. No, it's not a political meeting. We're giving a background in terms of like what is happening and where this came from. So as we move forward in understanding this background as to where this came from, we get here to where we are now, SNAP. SNAP was cut down by $186 billion, almost $187 billion, the biggest entrenchment in terms of how the SNAP program operates. Next slide, please. So why does SNAP matter, right? It is our largest anti-hunger program and one of our most effective tools for reducing poverty. It provides monthly benefits to households to buy groceries, right? That means that money is going down into local economies. It isn't just a nutrition program. It stabilizes families, that strengthens local economies. As we saw during the shutdown, many individuals had to choose between purchasing food and being able to pay for rent, or being able to pay for childcare, other basic needs that are incredibly important. And we saw many local economies try to step up, but they can't meet the gap for federal disinvestment. It also reduces long-term health and educational costs. And every dollar in SNAP generates up to $1.80 in terms of economic activity. Importantly, SNAP is incredibly targeted, and this is the point that we want to make, right? It's a mean tested program, meaning that it's based on income, on resources, on and also on immigration status. And the benefits that individuals receive are calculated on household size and circumstances. Next slide, please. I mentioned that there was, SNAP does provide significant economic generation. And even just if you look at what the small grocers are, which is just a small percent, it does provide over $1 million in taxes, 16 billion in wages, jobs. Again, it is incredibly important for our economy. Next slide, please. So who utilizes SNAP? In terms of demographics, we do know that the largest percentage amount are, our white community, and then less than, 26% is our African American community, and then about 16% is our Hispanic community. And those are terms that USDA utilizes, so we're just copying from the terms that they utilize. And there's a direct correlations between SNAP utilization and food insecurity, right? Our white community has a food insecurity rate of 60%, while our African American community has a food insecurity rate of 42%. Hispanics have a 40%. Next slide, please. And who utilizes SNAP the most? Majority of SNAP users are children, followed by older adults, and then people with disability. And also, majority of people who utilize SNAP, almost 96% of them are U.S. citizens. There's a small bucket, about 3%, who are eligible citizens, legal permanent residents, and then there's a small bucket, less than 1.1%, who are eligible non-citizens, which include refugee and asylees. But as we're going to talk about, there's going to be changes in sort of the participation that is within SNAP. Next slide, please. Some of those cuts that are going to impact anyone within the SNAP program, regardless of immigration status, who are in the program, is they're going to see if they fit into certain categories, such as time limits, they are going to be cut off if they can't meet certain exemptions. What this means is that all of these specific changes that are coming down the line in terms of SNAP are going to cost your state additional funding, and is going to require additional resources. And that means that your state will have less resources to respond to disasters or issues as individuals not being able to participate in the program. Next slide, please. And just so for the context, so that people understand the result of HR 1, the sort of the biggest cuts, one of the provisions is that individual states are now responsible to pay a higher percentage of administrative costs, including cost share, meaning the benefit amount that SNAP gives. It is projected that, our most populous states will be required to pay, in addition to what they usually pay, almost, billions of dollars. And those are monies that, while states may be able to upfront the money, it's money that could have been utilized for other basic needs program, right? And so it's important to contextualize that while federal inaction does cost, is that states have to, for the first time in history, put SNAP as a line item budget and shift money around, which will be incredibly detrimental for states. So we are very concerned how that is going to impact individuals. Next slide, please. And we love our superhero food pantries and food banks who are doing an amazing job. That being said, we do know that the charity sector cannot do it alone. For every meal that a food bank provides, SNAP provides 9, on top of allowing people the choice to purchase food at any hour, and also support their local economy. Next slide. Next slide. Okay, go back one. I apologize. So in terms of the background, in terms of like where we are today, before HR 1, right, before July 4th, it's important to understand sort of like, how do we get here? I mentioned that some of the requirements for people to turn SNAP is like they have to meet certain income guidelines, and residency status, meaning they have to live in the state where they apply, but they also need to have their immigration status, right? If you're a U.S. citizen, automatically you check off the box, that's it. But if you're not a U.S. citizen, there are specific rules that stem from a rule, the Personal Responsibility Work Opportunity Act of 1996, that not only impacted immigration, but also other provisions in other public benefits program. So under this Personal Responsibility and Work Opportunity Reconciliation Act, excuse me, only qualified aliens, and again, that is the term that is within the act, were able to access SNAP through various ways, right? So lawful permanent residents, refugees, asylees, meaning humanitarian-based individuals, individuals granting withholding of removal, Cuban Haitian entrants, Amerasians, certain parolees, and there's a long list. But there was an understanding of what individuals in different pockets could access this. They're also putting a provision that individuals who had legal permanent residence had to do something called a 5-year bar, unless they met other exemptions, right? Children, a 5-year bar. When all of this happened, there was a chill effect, and many individuals dropped off the program. States, noticed that there was a higher increase in food insecurity, and then there were certain revisions, including the people with disabilities, and also children under 18 would not be holding to that 5-year bar if they were legal permanent residents. Okay. And in addition to that, Congress created critical exemptions for humanitarian immigrants, right, such as refugees, asylees, and so on, that they would also be exempted from that waiting period when they adjusted from legal permanent status. So where we are now, HR 1, on top of the other provisions that we briefly went out there, is that it fundamentally alters immigrant eligibility for nutrition assistance. It eliminates automatic eligibility for humanitarian immigrants, and my colleague's going to go more into that when I turn it over to her. But it's important to note that right now, the statutory protections still exist under legal permanent residents. The legal permanent residents are still eligible to apply, right? That, the 5-year bar doesn't apply to children under 18. I want to make sure that people are aware that the Cuban Haitian entrants also are exempt from this, and also COFA. We're going to go into more details, but we wanted you to get a background as to how the SNAP program operates and understand the various hurdles that individuals need to access. Now I'm going to turn it over to our colleague, Meredith, who is with Meredith Owens, who is the Senior Director of Policy and Advocacy, RCUSA, and which is the Refugee Council USA. And she has worked in both the federal and state government, and she has worked as a director of policy. And she's going to tell us who are the people within this community who are going to be impacted and who are being impacted by the changes of HR 1 and other changes that have been happening within this administration. Meredith, turning it over to you.
Thank you so much. Hi, everyone. So I'm Meredith Owen with Refugee Council USA, and I'm going to be talking about humanitarian-based populations and eligibility impacts. So right now, refugees and asylees, among others, are no longer eligible for SNAP upon arrival or granting of asylum. And there's a distinction for refugees and asylees with green cards, as well as Afghan special immigrant visa holders who assisted the U.S. mission while we operated in Afghanistan. States are grappling with the question of whether whether refugees and asylees with green cards and whether Afghan SIVs who arrive to the U.S. with green cards should be subject to SNAP waiting periods. It is our opinion, based on the reading of HR 1, that the refugees and asylees with green cards and Afghan SIVs should remain exempt from and not subject to SNAP waiting periods. And I'm putting into the chat function a couple of, I'll come on camera since, yeah, there we go. I'm putting into the chat function a couple of legal analysis documents that can help spell that out further. And I will put into the chat function as well a helpful explainer from one of RCUSA's members, Church World Service, which is also a refugee resettlement agency that works with these populations. Okay, so then on Halloween, on October 31st, the USDA issued its guidance that was specifically speaking to the humanitarian-based population's eligibility modifications. And thanks to our friends at NILC, I won't go into it, but they created this helpful guidance on USDA's guidance that spoke to the ways in which it was deficient and confusing and contradictory. And in response, as states were grappling with these really important questions, we saw 21 different attorneys general write a letter to the USDA urging them to clarify that refugees and asylees with green cards and Afghan SIVs should be exempt from any SNAP waiting periods. I put a link to that letter into the chat function as well. Later that month, we also saw 21 states plus the District of Columbia sue the US government over immigrant eligibility. And I'll put the New York Times article with the press release of that lawsuit into the chat function so folks can click on that. It is interesting to note that oral arguments are actually coming up next week on Monday, December 15th in Oregon. So if you want to track that lawsuit, now is a really good time. And then also something to track is another lawsuit in Indiana. Exodus Refugee Service is a local resettlement site in Indianapolis, Indiana. And alongside the ACLU of Indiana, they have sued the state of Indiana around immigrant eligibility. I also wanted to point out a bright spot in Illinois. I'll put the link to the language into the chat function. But in Illinois, they specifically wrote language that because the current federal guidance does not provide sufficient clarity or direction to implement the changes around SNAP eligibility for non-citizens, that they would not be making those changes and referenced the state lawsuit. I'll put an action alert into the chat function for folks who are interested in engaging their members of Congress, their state legislators, and their local lawmakers. We're continuing to drive attention to this really important issue as states continue to grapple with this question. And we know that there are so many things hitting the media these days. We don't want this really important issue to get lost in the sauce, particularly given the acute needs that newcomers face when they arrive to the US. So that brings me to what are the acute needs that refugees have, and how are they uniquely affected by HR 1? So historically, the US resettlement program has been a public-private partnership focused on rapid economic self-sufficiency, focusing on finding refugees housing, job placement, enrollment in school, signing up for SNAP, healthcare or Medicaid, getting Social Security cards, work permits, enrollment in English language classes, explaining how to use public transportation, if that exists in that town, cultural orientation, etc. That's all within the first 30 to 90 days after arrival. After 90 days, depending on the evaluation of each case, there are longer-term programs like intensive case management, employment training, financial literacy programs, legal services for adjustment of status applications, naturalization, etc. Refugees arrive with a couple of suitcases and a history of displacement. Some were born in refugee camps. Others have been displaced multiple times. Many don't speak English. And refugees come from all over the world: Afghanistan, Somalia, South Sudan, Burma, the DRC, Honduras, Ukraine, and many other countries. Once they arrive to the US, they aren't making like $100,000 a year. In Vermont, for example, refugees make approximately $17 to $22 per hour on average. And even with two full-time earners, refugee families with more than two children struggle to meet basic needs. For an example, we have an Afghan SIV example who was recently resettled in Vermont, an Afghan widow whose husband was killed by the Taliban. She has 5 children. She works full time. She has learned to drive. She now owns a car, but her hours were recently reduced at work. And what is she supposed to do? If she no longer has access to SNAP, she has to choose between affordable groceries and other things for her family or figuring out other kinds of training programs to make a better life for herself. In addition to the real effects on refugees themselves, there are also challenges frontline resettlement and case management staff face. This year, we've seen an unprecedented and nonstop attack on refugees, Afghan SIVs, and humanitarian and immigrant populations, dismantling our capacity to welcome and devastating the nonprofits that exist with the technical expertise, with trained case managers to provide tailored services. And I say this to say, this is all in context for refugee serving organizations. We have Trump's discriminatory resettlement program with an indefinite refugee ban that's still in place, record low refugee admissions goal, a priority for Afrikaner resettlement, a pattern of the administration's unlawful actions violating statutory obligations, um, uh, issuing collective punishment against refugees, Afghans, asylum seekers, Somalis, travel ban nationals after the DC shooting. And you see a complete rearranging of how the US resettlement program is operated by the federal government and transferring who is responsible for administering this program, specifically around domestic services from the State Department to the Office of Refugee Resettlement at a completely different federal agency with more changes to come. So we're drinking from a fire hose in terms of what refugee serving agencies are experiencing. So SNAP is one of those things. It has a huge impact, and there are a litany of attacks that are happening all at the same time. So I'm going to put a couple more resources into the chat function, and with that, I will yield my time back to Gina.
Thank you, Meredith, and thank you for providing such a picture of the vulnerabilities and how harmful this is. Our next panelist, Sarah Krieger, who is a senior counsel at the National Immigration Law Center, is going to take us to a deeper dive as to what the specific section that we have been referencing in terms of the changes as to SNAP and why we need to be aware of its impact, like Meredith said. Sarah, turning it over to you.
Thanks so much. Thanks for having me, everyone. So now that Meredith and Gina have talked about the importance of SNAP and how a lot of vulnerable populations are uniquely and acutely affected by HR 1, I want to talk about the specific provision in HR 1 that changed SNAP eligibility. So it's section 10108 and it's titled Alien SNAP Eligibility. So what this section does is it modifies part of the Food and Nutrition Act of 2008. It modifies section 6F, and it restricts SNAP eligibility only to US citizens or nationals, lawful permanent residents, sometimes called LPRs or green card holders, people who are Cuban or Haitian entrants. These are certain people who are from Cuba and Haiti. And then finally, individuals who are residing under a Compact of Free Association, also known as COFA. So as we talked about earlier, prior to the passage of HR 1, all these categories of people were eligible, but also a category of people called qualified immigrants were eligible. And a lot of qualified immigrants were parts of vulnerable populations like refugees and asylees, survivors of trafficking. So essentially what this section does is it eliminated eligibility for SNAP for a group of qualified immigrants, and it restricted eligibility to just these categories that you see on the slide. So now if people do not fall in one of these categories, they're not eligible for SNAP. That includes refugees, asylees, certain parolees, meaning people who were paroled into the United States, survivors of domestic violence and human trafficking, and others. As was noted a little bit by Gina, there is a 5-year bar for certain immigrants before they can get SNAP. But the 5-year bar continues to apply to people who are subject to it. But there are many populations of people who are not subject to the 5-year bar. So, for example, the 5-year waiting period before you can get SNAP does not apply to people who once were humanitarian immigrants, like they were refugees or asylees, but are now green card holders. Once they become green card holders, they become immediately eligible for SNAP and they don't have to wait 5 years. Another thing that I want to flag is that HR 1, this reconciliation bill, didn't change the rules for household eligibility. It just changed the rules for individual eligibility. And just to confirm, it modified the Food and Nutrition Act, not what we call PERORA, the Personal Responsibility and Work Opportunity Reconciliation Act. And that's the law that initially set out what qualified immigrants are and put the 5-year bar into place. So one of the problematic pieces of many of part of HR 1 is that it did not change the rules, and it did not specify an effective date for the changes in the rules. After the passage of HR 1, there was a lot of confusion and fear about implementing these changes due to there being concerns about error rates, due to states being concerned about funding. And then on October 31st, as we talked about, the Food and Nutrition Service issued implementation guidance in the form of a memo indicating that states had to apply new eligibility criteria immediately. They would have to, for new households, and they would only have to apply the criteria upon recertification for anybody who was already in an existing household that had SNAP. Next slide, please. So let's talk about this FNS guidance, the Food and Nutrition Service guidance. So as we've talked about, they finally issued guidance in October, a few months after the law came out. And the guidance states that the new eligibility criteria is effective immediately for new applicants. They gave states basically no time to prepare for implementation. And as part of this memo, it also includes a chart that's supposed to lay out eligibility for SNAP for various groups. But unfortunately, the chart and the guidance did not help ease the confusion around HR 1. So I'm going to quickly go through little parts of the guidance, walk through it. We'll talk about how various states have approached the issue of SNAP eligibility post this guidance, and then what best practices might be. Next slide, please. So here's a little snippet from the memo. As you can see, the memo does correctly note that eligible immigrants continue to be subject to a 5-year waiting period unless they're exempted by PERORA. That's the first highlighted portion. And PERORA, again, is the law that sets out the 5-year bar. And this guidance does cite to the relevant portion of PERORA, but the chart directly below it and additional charts that we'll look at provide conflicting information. So you can see under the row that says lawful permanent residents, it says they still may be eligible without a waiting period if they meet one of the below conditions. And if you take a look at the conditions, it says someone's age, their work quarters, if they're blind or disabled, if they were lawfully residing, if they have a military connection, if they're an Amerasian, or an American Indian born abroad, or they're certain Hmong or Highland Laotian tribal members. But you'll note that it's missing all of the humanitarian immigrants who are not subject to that 5-year bar. So as we've said several times, but we'll keep saying it, those exemptions are found in PERORA, and HR 1 did not change that. So the chart from FNS and any state implementation should reflect that people are still not subject to a 5-year bar if they were previously a humanitarian immigrant. Next slide, please. This is another chart that's in the Food and Nutrition Services guidance that talks about, it says, for example, that asylees are not eligible. You can see or victims of severe trafficking and certain family members are not eligible unless they're an LPR. Well, it should say not eligible unless an LPR, then eligible immediately, like it says in another field. And it says in the refugee row, not eligible at all. It should also say not eligible unless an LPR, then eligible immediately. So it's just really confusing and doesn't clearly indicate throughout what groups do not have to wait 5 years before getting SNAP. Okay, next slide, please. Thank you. So big picture, Green card holders, LPRs, lawful permanent residents who previously held a humanitarian immigration status are still not subject to a 5-year waiting period and are eligible immediately upon becoming lawful permanent residents. This FNS guidance is internally inconsistent. It's causing a lot of confusion, not just among impacted individuals and people who get SNAP, but also for state agencies. So states have taken differing approaches, and on the next slide, we can talk about what those are. So next slide, please. So because of this confusion, some states are finding that certain humanitarian immigrants who are now green card holders don't have to wait 5 years. Some are saying they do have to wait 5 years. Some are saying only certain categories have to wait and others don't. It's just a very confusing mess. So 21 states in November 19th, the states that I've listed here on the slide, wrote a letter to the Secretary of Agriculture asking them to retract the guidance that we just looked at and to correct all the errors that were in there, because they agree that, you know, those individuals do not have to wait 5 years based on the Personal Responsibility and Work Opportunity Reconciliation Act from 1996. Other states have not joined this letter, and they have inconsistent or inaccurate interpretations, which is leading to a lot of eligible individuals being wrongly denied benefits. And I know states vary by practice. So if your state is one of them and you need help with that, you know, definitely reach out, or ask them. You feel free to ask questions in the chat, and we can talk about other practices. So the last thing I want to talk about, on the next slide, please, is best practices for advocates. I don't know if maybe it's not up there, but the first thing to do is, if you're an advocate, make sure to provide clear information about eligibility. Make sure that impacted communities understand who remains eligible for SNAP and who is no longer eligible. If you are in the place where you can provide public-facing guidance, please try to provide it in a variety of languages to ensure that you reach as many people as possible. If you know of individuals who are wrongly denied SNAP, or you were wrongly denied SNAP, appeal immediately. You know, using the state attorney general the letter that they wrote may help in an appeal. They have a very clearly laid out legal argument. It could not hurt to attach it and include it in any appeal. I'll put it in the chat. That's the letter. And then, you know, stay updated on all the SNAP related changes. You know, these kinds of webinars, you know, check out FRAC's resources and the resources Meredith put in the chat as well, because things are constantly changing. But it's really important that we keep ourselves armed with whatever information exists and push back on any inaccurate representations. So that's all for me. Feel free to, if there are any questions, happy to answer them in the Q&A, and I will give it back to Gina. Thanks.
Thank you, Sarah. And thank you so much for mentioning appeal. That's something that individuals need to know. Just because you request an appeal, it doesn't mean that the appeal is going to happen right away. But it does ensure that, you know, there is a provision to ensure that your benefits you can appeal any sort of rejection for your benefits, and do contact us so that we can see who in that state can help you with that appeal. So thank you so much, Sarah. Now we're going to turn it over to Elizabeth Lowerbash, which is the Protect Immigrants campaign. And the reason why I say that is because Elizabeth has a very difficult job in sort of summarizing all of the negative impacts that have been impacting immigrant communities, not just in terms of SNAP, but in public benefits and in other spaces as well. Elizabeth, turning it over to you. And I should just say that, you know, Elizabeth is with the Protect Immigrant Families Coalition, and she is an expert within this field. She's been in the anti-hunger community for years, she was a deputy executive director of policy at the Center for Law and Social Policy. She knows this field very well, and we're very fortunate to have her over at PIF. So Elizabeth, turning it over to you.
Sure. Hi. So I'm going to pivot a little. I'm going to talk about some of the things that have been happening that are not direct eligibility changes to benefits, but that have been scaring people who remain eligible for programs away from receiving them. And as Gina said, I am here today representing the Protecting Immigrant Families Coalition. I have lots of slides so that you'll have them when you get the slides sent out. I am not going to cover everything that's on the slides because I do want to leave time for questions. Next slide, please. So one of the things that's happening is, since the very start of this administration, there has been an onslaught of activity coming from the White House that is designed to have a chilling effect on immigrants and access to benefits, ranging from birthright citizenship to official language designations, quote, sanctuary jurisdictions. The executive order that was most directly about public benefits has this terrible title about protecting Americans against invasion. The language is just horrific. I try not to repeat their framing when I can avoid it, but there's really been an onslaught of activity from the very top. Next slide, please. And in particular, there's been a set of activities around privacy and data sharing. The White House frames this as silo busting, but what they are doing is building a database or a data lake of information, in many cases, information that agencies specifically promised the people would never be shared for another purpose. And they seem to be turning it over to DOJ and to the Department of Homeland Security. So tax information, particularly about people who file with an individual taxpayer identification number rather than a Social Security number, they've asked for information from Medicaid and Social Security. And as I will talk in a minute, they've asked for information from the states about SNAP. Next slide, please. So FNS demanded that states shared individual level SNAP data going back to January 1st, 2020 on everyone who's applied for or received SNAP benefits, including names, dates of birth, addresses, Social Security numbers. They claim this is for program integrity, but as most people on this call probably know, SNAP has its own program integrity system, quality control. It does not seem likely that this is actually being used for program integrity. We do know that 29 states did share data with FNS. 21 states in DC have not done so, and in fact have sued FNS to both oppose the demand and also protect themselves from the penalty that FNS is threatening, which is withholding administrative funds. As you may have seen, just in the last week, USDA Secretary Rollins has been widely quoted as saying she's going to withhold SNAP administrative funds from the states that have not complied. This is even though there's a preliminary injunction issued by the courts that specifically forbids USDA from imposing penalties. And yes, we will share the recording, we will share the slides. For those who really want to get into the weeds on like data sharing and litigation, the previous slide has a link to the executive action tracker that we've been updating that really follows all these sort of wonky in the details things that the administration's been doing to make people afraid to access benefits. We do hear a lot about the data sharing. I think first, just no one likes the idea of their data being shared and they don't know what it's being done with. But also there's a lot of concern that it's going to be used to send ICE to people's door. Just again, naming, while people who do not have documentation are not eligible for SNAP benefits, if they have children who are eligible or other family members who are eligible for benefits, those people are able to access SNAP. Next slide. So the other thing that has happened is the administration has released a new public charge proposed rule. And some of you probably know a lot about public charge, and some of you, this is the first time you're hearing it. I'm going to try to do the very high level version of this, and I'm happy to send more materials to people if they want more follow-up. So public charge is a policy that says when you apply for a green card, for an LPR status, their application is reviewed. And if the immigrant is likely to primarily depend on the government for support in the future, then they can be denied. An important thing to note is that the public charge test is not part of all immigration applications. Next slide. So specifically, family-based green cards, visas to enter the US through the Department of State, some employment-based visas have public charge tests. In most cases, refugees and other humanitarian immigrants are not subject to a public charge determination when they try to get their green cards. Next slide. Just without getting into a lot of details, public charge is not just about use of benefits. By statute, DHS is supposed to look at a wide variety of factors, and it's supposed to be a forward-looking assessment. It's not about what happened to you in the past. It's about what is expected that you'll need in the future. Next slide. So, last month, November 19th, DHS posted a new proposed rule on public charge. They provided only a 30-day comment period, which means comments are due in 10 days, December 19th. And this proposal rescinds the current regulatory language about public charge, other than a small piece about bonds. It does not offer new language, and it does not formally rescind the field guidance that has been deriving public charge before that. It basically says we're going to take away this rule, and at some point in the future, we're going to create policy and interpretive tools that are going to guide USCIS adjudicators as they make decisions. So that's really hard to sort of think about. Next slide. So people will typically respond to this with lots of questions about, well, does this mean this counts? Does this mean SNAP counts? And the basic answer is we don't know. The proposed rule removes the language saying that only cash assistance for income maintenance and long-term institutionalization at government expense will be considered. And it similarly removes the language that specifically guarantees that receipt of benefits by other family members is not considered receipt. And it suggests that current or past use of benefits could be considered. So this is quite terrifying to lots of people. One thing to flag is another thing that was in the 2022 final rule. Specific language was that if people in a status that is exempt from public charge, such as refugees, receive benefits while in that status, and then later, for example, they marry a US citizen, and so that they try to get a green card through that pathway rather than the refugee pathway, the use of benefits would not be held against them. That's another of the protections that this proposed rule would remove. Next slide. So, as I said, there's a comment deadline on December 19th. Not the main focus of this webinar, but we would love it if people are able to comment on this. And Protecting Immigrant Families has created a whole bunch of resources. There's a sign-on comment, so if you don't have the bandwidth to write anything new yourself, but you are able to sign on, we would love that. We really want to see as many organizations nationwide, state, local, national organizations signing on to show broad opposition to this. There's a very detailed template for those who want to go into the weeds, and also a shorter template if you work directly with immigrant populations, and you can talk about the confusion that you're seeing, the questions that people have, how you've relied on the previous public charge guidance to inform your work. That's all really useful things for you to share in the comments. Next slide. So the big question, and I think we're going to have more time in the Q&A to discuss this, is how do we talk about this with people, both public charge, but also the data sharing, and frankly, you know, in the whole context of attacks on legal immigration as well as enforcement. A lot of people are really struggling. And I think the main point to lead with is that our job is not to persuade people to apply for benefits, but to give them the information they need to make the best decision, an informed decision for themselves and their families. And sometimes that will be to use benefits and sometimes it won't be, which can be hard to realize. Some factors to consider. Does DHS already have their information? If you're a refugee, if you have an application pending, you're supposed to update your address with them anyway. They probably know where you are. If someone doesn't have any pathway to a green card through a channel that's subject to a public charge determination, maybe they don't need to worry about public charge. I think there's a question about how much do people need the benefit and if there's another way to receive the help they need. If they're working and only getting the minimum benefit, that might be a different cost assessment than if this is the only benefit people are getting if they're not working and they're really relying on it to feed their families. So we need to trust people to make good decisions. Next slide. And again, this is mostly so you'll have the links when you get the slide, but PIF has put together a bunch of community messaging on both of these topics. The data privacy piece, the 5 things you need to know, is already available in 9 languages. If you have the capacity to help us translate into more, we're happy to work with you on that. The public charge materials so far are about in English and Spanish, but PIF is working to get that in more languages as well. And with that, I think I'll invite the rest of the presenters to join me and we'll all do our best to answer questions.
Thank you so much, Elizabeth, Sarah, and Meredith, for your great feedback. We know this is a difficult topic and we know information is out there. We also want to note that FRAC is also doing a sign-on letter, but it's very specific on the nutrition impacts, right? The way that administrative review works is that by law, the administration needs to read each unique comment, right? So it's important as they're reviewing this that they get, these comments so they could say how will impact you. The more personalized that you can make it, right? Your home community is very different than my home community. How will this will impact? And, we have for FRAC, it's very specific onto the nutrition programs, right? All of the nutrition programs, what we may think will be impacted. So just want to make sure that we are working in tandem with PIF. But if you are a subject matter expert, if you have like the health aspect, the mental health aspect, whatever within your space that you can make and tailor comments, feel free to do that. So if you care about nutrition, that's what we're putting out there. And we also have a sign-on letter for those of you who may not have the bandwidth. So just want to make sure that we start with those questions. And I know we answered quite a lot of questions already in the Q&A, but sorry, give me 1 second. Just want to make sure that we answer it for everyone as a whole. Sarah or Meredith, are Ukrainian refugees impacted by these changes in SNAP?
Yeah, so if for Ukrainians who would have arrived through the U.S. resettlement program, they would have had refugee status, which means that if they still have that refugee status, they are no longer eligible for SNAP. If they arrived and they've since adjusted their status and received their green cards, they may or may not remain eligible for SNAP, depending on the state. If they arrived through parole, they would not be eligible for SNAP anymore. If they applied for asylum, had been granted asylum, and then applied and received their green card, they may or may not be eligible for SNAP depending on the state that they're in.
Sarah, anything to
Hope
add?
that helps.
No, that was very comprehensive.
Okay. One thing I do want to add is that, These individuals and these statuses, when we talk about adjustment of status, is that we're switching from asylee, refugee to a green card holder, a legal permanent resident. That process of asking, for the most part, it used to take 3 to 6 months for folks to be able to get their green card. That has been frozen. So I just want to flag that. And I also want to flag that if you are working with clients who have adjusted their status, who have their green card, and they just haven't contacted your state agency, do it and say like, oh, by the way, because the system is called the SAFE, and Sarah's our expert on this, that's supposed to sort of update people's statuses. It's not up to date, right? So your state SNAP state agency may not have the latest immigration information. So it's very important that if you are working with someone that already has a green card, before they get that notice that says you're no longer eligible, that they call the state agency so that there is no disruption to their benefits. Okay. So that's your homework. Make sure that you speak to clients that you may be representing and let them know that if they already have adjusted status, that they contact the state agency. Elizabeth, this might be for you. Would public charge apply for children only receiving benefits in mixed status households?
So in most cases, children in mixed status households that are themselves citizens, and public charge never applies to US citizens. And it does not apply to green card holders when they apply for naturalization. So it should not matter. The thing that people are worried about is if you have a parent who's applying for a green card and they're not getting benefits, but their kids are, will that be held against them? And the current regulation says very clearly it will never be held against you. They're taking away that protection, which is just, we don't want to tell people it's safe if we can't, if that we're not sure it's true. So we just don't really know.
Yeah, and and then that's one particular piece where they say that they will tell the USA officer that they will determine things. Immigration law cannot be subjective. We need like clear guidelines, because we just don't want anyone to have implicit biases. People need to know what sort of requirements, and immigration law is already subjective as is, particularly when people are applying for consular processing and so on. So it's just very important to have this clear guideline. So it's very important that all of you, please, today you get off, do sign in to the letter, but more importantly, submit comments. I also want to add that FRAC also created a resource on talking about what the data request means for USA. I know we've been getting a lot of concerns. Secretary Rollins 2 weeks ago made this flawed statement that said that if states did not comply, she was going to take away SNAP benefits. And then the next day, someone from her administration said, "Oh, that's not what we meant. If there were to be an administrative funds, which is really what the first notice said, there has to be certain protocol." So it's very important that people are aware where we are and we have resources. And I really appreciate you, Elizabeth, saying that it's not our job to convince people. We are not in this situation of what it means. No, this is a real fear for individuals who are living every day. So we encourage to look at our resources where we really have spoken about this as well. I don't know, Elizabeth, if you want to add anything else.
Yeah, no, I think that's right. I mean, in the data sharing, they're clearly just trying to penalize, frighten states that are standing up for immigrants and for their communities. So,
yeah, I know we're winding down, but if Meredith, Elizabeth, and Sarah, if you can just in 30 seconds, just share with us, what is the best practice that you think all of our advocates should be aware of in dealing with these communities as we continue facing different attacks?
Stand in solidarity. It is really important that we recognize that every different stakeholder or part of the community is being attacked in different ways, but everyone, the attacks against refugees and immigrant populations is also impacts everyday Americans, and vice versa. We're in this together. And that is why it is so important to engage our congressional, state, and local policymakers, to engage them to hold the administration accountable.
Yeah, I mean, I would echo that for sure. And just emphasize that these changes are intended to be confusing and cause chaos and fear. And so the more that people can kind of disentangle this messy web of eligibility and the more they can provide clear, consistent information to impacted communities in language they understand, the more we will ensure that people get the assistance that they're eligible for and that they rely on.
Yeah, and sort of putting those together, that, you know, we are all working together to fight back on this, you know, public charge rule. We've got a nationwide campaign to fight on it, that states are suing the federal government, that like no one should feel like they're in this alone. And that we really all do need to work together to so everyone can have the food and other benefits that they need to thrive.
Thank you. And thank all of you for attending here today. And the main thing is make sure that we elevate those voices. There may be these vulnerable populations who may not feel comfortable going to their state representative. Remember, state representatives are thinking about legislation and budgets, about how to offset some of these harms to your members of Congress, but you may be in a position where you can speak up. And we are here to work with you on talking points, on connecting you with those resources so that you have the most up-to-date information. Please do a comment if you have any questions or need technical assistance. PIF is helping with technical assistance. We're doing it in the nutrition space. And those are other ways that you can talk about it. Supposedly, everyone cares about children not going hungry. So it's very important that we really highlight those things to our members of Congress, particularly as they'll be going home for the holidays. So please do reach out. Please let us know if you have any questions. We will follow up with this recording, with the PDF slides, with all of the resources that our wonderful panelists have provided. And thank you all so much for your time and your effort and your solidarity in this very important challenges that we are going through. Have a great day.